Councillor Fry, can you hear me? Councillor Fry, can you hear me?
I can hear you. Can you hear me?
Yes, I can. Thank you. And we have the licensee on
Yes.
line as well. Puneet Kochar, can you hear me, Puneet?
I can, yeah.
Sorry, Puneet, we're having trouble hearing you.
Oh, can you hear me now?
Yes, we can. Thank you. Just you may want to increase the volume or raise or try to speak a little louder into the mic.
Sure, I can do that.
Okay, thank you.
Thank you, Ms. Kochar. The hearing before the panel this evening is an appeal by the licensee of the Chief License Inspector's decision to suspend the business license issued to her on February 8th, 2022 for the provision of short-term rental accommodation at Unit 802-183 Kiefer Street in the City of Vancouver. A copy of that license is contained under the materials at tab 4, paginated at page 18 in the top right-hand corner. The suspension by the Chief License Inspector and the basis, therefore, is set out in the letter of August 31st, 2022 to the licensee, which is included in the materials at tab 14. And I'm just going to read a portion of that letter for you. The page number in the upper right-hand side is page 192. This is the suspension letter from the Chief License Inspector, and you'll see from the second paragraph in the letter the basis for the decision. I'll just read that for the panel. The city has determined that in consideration of the totality of information, including documentation provided during your audit, information received from the community, the compliance inspection, and information from the meeting, the information does not support that Unit 802-183 Kiefer Place is your principal residence. As per License Bylaw 4450, Section 25.1 sub 3, no person shall carry on business as a short-term rental accommodation operator unless the short-term rental accommodation being provided is the principal residence unit of that person. The letter specifically stipulates that the basis for the suspension was due to the licensee failing to satisfy the principal residence requirement for the premises. There is a definition of principal residence unit in the license bylaw, and I'll read that for the panel now. A principal residence unit means the usual dwelling unit where an individual lives, makes their home, and conducts their daily affairs, including without limitation, paying bills and receiving mail, and is generally the dwelling unit with the residential address used on documentation relating to billing, identification, taxation, and insurance purposes, including without limitation, income tax returns, medical services plan documentation, driver's licenses, personal information, vehicle registration and utility bill, and for the purposes of this bylaw, a person may only have one principal residence unit. The witness on behalf of the Chief License Inspector today is the city's Deputy Chief License Inspector, Mr. Koji Miyagi. He will take you through the materials in the evidence book and explain the basis for the Chief License Inspector's decision to suspend the business license. What the panel can expect to hear is an indication that the decision required a weighing of the claim of principal residency by the licensee against a number of other factors, namely a high booking volume, an admission with respect to long-term absence from the unit, an admission with respect to moving out of the unit in May 2022, admissions with respect to alternative housing for long-term purposes, and the fact that the listing was listed for long-term bookings in and around September 2022. That's something that the panel can take into consideration. There was also an inspection of the premises prior to the decision to suspend, and it was indicated that the residence was cleared of any personal effects while being offered for short-term rental accommodation. The Chief License Inspector's submissions to the panel is that the conclusion that the evidence did not support principal residency was a reasonable one, that the suspension of the license logically flows from that, and that the decision to suspend should be upheld. Of course, the licensee has the opportunity this evening to convince the panel otherwise. Before embarking on the evidence, Mr. Miyagi, there are some legal and procedural issues to note. First, the Chief License Inspector's power to suspend the business license is set out in Section 277 of the Vancouver Charter. That reads, the Chief License Inspector shall have the power at any time summarily to suspend for such period as he or she may determine any license if the holder of the license has, in the opinion of the inspector, been guilty of such gross misconduct or with respect to the licensed premises as to warrant the suspension of the license. The city's submission is that the short-term rental of the property that falls outside of the regulations with respect to the principal residency requirement would amount to gross misconduct. Furthermore, in the charter, this council's powers to review a business license suspension is further set out in that section, being that any person whose license has been suspended under this section may appeal to the council in accordance with the procedure for that purpose prescribed by bylaw, and upon such appeal, the council may confirm or may set aside such suspension on such terms as it may think fit. The panel's power to review a business license are set out further in Section 275 of the Vancouver Charter. The granting or refusing, and I'm just reading that now, the granting or refusing of a license to an applicant, therefore, and the revocation or suspension of a license which has been granted shall be deemed to be in the discretion of council, and the council may grant, refuse, revoke, or suspend a license without stating reasons, therefore, save in respect of a license licensee who, by reasonable efforts, could not be found, the council shall not revoke a license without giving the holder thereof an opportunity to be heard. And that opportunity to be heard is part and parcel of this evening's proceedings. But under that section, this panel has broad powers to revoke, suspend, or uphold a business license. This is an administrative proceeding, so rules of natural justice do apply, including that opportunity to be heard. But also the license holder is entitled to hear the allegations against them. They may respond to those allegations. They may ask questions of the witnesses, and they may make submissions on their own behalf, including the provision of any further materials that they see fit. If this panel, though, sees fit to uphold the suspension, overturn it, or overturn it and stipulate conditions to be attached to the business license, because that's also an option. The law does state that you must give reasons for doing so. That's a Supreme Court of Canada decision of Regina and Vavilov. Those are the opening remarks. From this point, the city will call the evidence of its only witness, Mr. Koji Miyagi.
Welcome.
Thank you, Madam Chair. Thank you, panel. Thank you, Mr. LeBlanc. My name is Koji Miyagi. I am the Deputy Chief License Inspector for the City of Vancouver. I am also the Assistant Director of Community Standards, and that is an area in the Development, Buildings and Licensing Department. I oversee 3 enforcement branches, and one being called proactive enforcement. That area oversees the enforcement, the compliance, the investigation for short-term rental license issuance. And the information provided here today in your evidence package was created from my staff and our area.
Thank you. And you're familiar then, Mr. Miyagi, with the property at number 802 183 Kiefer Street?
Through the chair, yes, I am.
And you had some involvement with respect to enforcement activities at this premises dating back to around 2021?
Yes, I go through the dialogue and we do triage on the case files, and so I am familiar with this.
This particular matter deals with a short-term rental license that was issued to registered property owner Miss Kochar, and I understand that licenses were issued with respect to this premises and that owner as early as 2020. Is that right?
Yes, through the chair, that is correct. She has had, I believe, 3 licenses with us. When I say us, I'm referring to the City of Vancouver.
Thank you, Mr. Miyagi. I further understand that at tab 2 of the materials, your staff has set out a timeline of the events with respect to the activities, enforcement or otherwise, with respect to short-term rental at Unit 802 183 Kiefer Place.
Yes, through the chair, and for the purposes of members of the panel, if it's not tabbed, it's page 5. Yes, our staff, my staff who have investigated this case file has laid out the timelines of the activities that we have engaged Ms. Kochar.
I'm just taking it from the top then, and perhaps I'll ask the panel members to turn to that page 5 under tab 2, and we'll start going through that timeline event, and you can explain how it is we're at the stage that we are at this evening. I see at the beginning reference to land title office. Records show that Ms. Kochar, the licensee, became a co-owner of the property September 9th, 2019.
Through the chair, yes, that's what our information reflects, and that information is in the evidence package. Appears she rented a place in Abbott prior to purchasing this 802 183 Kiefer Place.
Okay. We'll get to that Abbott residence, but shortly after the land title was registered on September 9th, or about a year later, there was an application by Ms. Kochar for a short-term rental license. Can you tell us about that?
Yes, through the chair, that is correct. She's applied for license on September 29th, 2020. And later on, we'll talk about her booking activities, but they started shortly thereafter.
You say September 29th, but the timeline says September 18th. Was 29th an error?
It's the issuance on the business license. It could be when she printed it out.
Okay. I'm just looking at, you're referring to the 2020 business license that's at page 16 under tab 4.
That's correct.
Okay, what I can take from the discrepancy in those dates is that it was applied for on September 18th and then issued or printed out on September 29th by staff.
That is correct. Yeah, the Amanda system would have registered it on the 18th.
Okay. The indication here was that there was no formal license application review. What does that mean?
So at the time of issuance, the licenses are self-generated, if you will. They apply online, and they follow the instructions that are online. And then if they check the appropriate the boxes and then pay the fee, then the licenses are issued automatically to that individual. And the reference to that statement is that given our staff limitations as well, we want to expedite the issuance of the license. We don't necessarily review or audit each application to its detail.
So there's an automatic issuance if the application is complete and the fee is paid.
Through the chair, yes, and it's a self-declaration application process, and so we state fairly clearly in there that you must provide truthful information.
The next note in the timeline of events is that there was a renewal of that business license for the next year, being 2021.
Through the chair, yes, that is correct, and this one was and it's frequent that people will renew prior to the end of the year.
And the next date entry, March 27th, 2021, it appears as though it was flagged for a complaint received through Van Connect. What is Van Connect?
Through the chair, Van Connect is it's tied to our 311 system. It's an ability for the public to online complain, lodge a complaint, and so through that Van Connect service that we have to the public, we received a complaint pertaining to this address.
And the complaint is pulled verbatim in quotes, being that the unit at 802 183 Kiefer Place was not the primary residence of the owner.
Yes, that is correct. They can cite a number of things. In this particular case, the complaint specifically said that they believe that the individual that's running the short-term rental at that particular address does not live there, and hence does not.
What did you do when you got that complaint, or what did staff do?
So for all complaints, the staff will receive them, and then we will look into them. We will start an investigation on them. We will create a case file and start a review process.
And I see here that it was flagged for license audit. An audit is something that's authorized under the license bylaw for a chief license inspector to conduct to verify things such as establishing the principal residency requirement.
Yes, through the chair, that is one of the very first steps that we take when we have a complaint, when we review its contents. We do we call it internally a stage one or a phase one audit, which is request for documentation, and it is identified in the bylaw as well as in the application process. It says very clearly that before you apply, please have all your documents in place. So therefore, when we ask for them, that you can provide it fairly quickly. And so that was the first steps that we've done.
And I read the definition of principal residence from the license bylaw, and it too indicates certain documentation that may be acceptable. Are those the types of documents that you request through the audit process?
Yes, through the chair, there are examples provided, and we ask for government issuance type ID, preferably with a photo. We look for things like as an example, Revenue Canada information. We try to look for information that is not self-generated. So ICBC information is one of the information that we also ask for. We do accept billings and those kind of information as well, but a lot of times they can be self-generated, meaning you can put down an address that you want on there. However, we do look at those as well.
The my understanding is that the audit was conducted that year and completed by August 31st, 2021, whereby the city passed the audit because it was satisfied by the documents that were provided. Is that right?
Yes, through the chair. In this particular instance, we looked at the information, and the individual provided the information, and at that time, our staff were satisfied that that documentation information was viable for the application.
In other words, the documents that were provided, to the extent that they were provided, they satisfied the chief license inspector with respect to the principal residency requirement for that unit.
Yes, that is correct.
And I'm just looking at tab 5 now, starting at page 19. It looks like the first, that first page, page 19, is a copy of the Van Connect complaint. Is that right?
Yes, page 19, sorry. That is the copy of the first complaint that we received.
And then page 20 through 22 would be audit notification letter that was sent to the licensee.
Yes, through the chair. So this is the document audit information, and it lists the types of documents to send within a particular time limit 30 days. We also ask for an operational summary, and then booking calendars if there are any. So in this particular case, we asked for the booking calendar because the license was issued well, December of the previous year for the current year, and there would have been a number of months that perhaps this location was active, so therefore we asked for that information as well. And then we often ask for if there is a property manager involved, we ask for that information as well.
Okay. The balance of the documents look like there's a booking calendar in here. There are some of those invoices, ICBC records, and whatnot. I don't think that we need to go through all of those, but these are all of the materials under tab 5 that were considered with respect to that first audit in 2021. Is that right?
Yes, through the chair, that is correct.
Okay. Do you typically do more on an audit, or is that the extent, the 2021 audit with respect to the 2021 license, is that your typical audit?
That is the most frequently initiated audit. Although it does take time, it is a bit more time conservative, and so we're able to perform a lot more of these. So yes, now we do a stage 2 or phase 2 audits where we actually interview and we also go on site and do an inspection. So those are ones that we may decide to do later on, or we may decide to do in conjunction with. In this particular time, we felt that the stage 1 audit was satisfactory.
Okay, so fair to say we'll call this a stage 1.
Sure.
And a subsequent one that we'll get to will be a stage 2 audit. Is that fair to say?
That's correct.
Okay, so that's 2021. The audit was completed at the end of August, and the license then was active through to the balance of the year. The next date entry, and I'm back to tab 2 at page 5 of the timeline, has an entry for February 8th, 2022. That indicates that the license was renewed. That's the renewal for the 2022 business year. Is that right?
Yes, through the chair, that is correct. Individuals can also renew their licenses online.
And that 2022 license is at page 18. I've already referred to that for short-term rental accommodation at Unit 802, 183 Kiefer Place. That's the license?
Yes, through the chair, that is the license that was issued.
Okay. Then following that February date, the city receives another complaint, this time May 17th, 2022.
Through the chair, yes, we received another complaint, and this one again was for a unit at this address. And I'd like to add that getting multiple complaints does certainly flag our interest. And as you'll see later on, there'll be a third complaint as well. So those really trigger the city's interest. Frequently, we actually receive no complaints for most of our licensees. And so when we receive one, we take some interest. When we receive two or three multiple complaints, then it does trigger our interest.
The complaint that's referenced under that May 17, 2022 heading is at tab 6, page 66 of the materials. Is that right?
Yes, through the chair, that is correct. That is the complaint, and this one particular states that the strata application or the strata permission is not provided. So it's different from the first one where it was a non-resident or non-primary resident concern. This one stated that it didn't have a strata, and if I can maybe explain what a strata permission is, short-term rentals that are run out of a condo unit, apartments that are stratified, require permission from the strata to indicate that that activity is actually allowed in the building. And so we look for that document, and once again, these are mandatory documents. So if you're renting a place, you also need to require permission from your landlord. So similar to that, the strata documentation is also a mandatory piece that is required. In this particular case, they said they don't have one. So that is also an interesting trigger for us to look into that.
Okay, can you explain that? They said they don't have one. Was there some investigation into that before an audit was launched?
Well, so the complaint says it's not allowed by landlord or strata, which is true. And for them to state that the complainant state that this particular unit doesn't have one, we need to verify whether that's a legitimate complaint or how that individual had that information or the complainant had that information. So in order to do that, we would, in this particular case, we started down the path of a phased stage 2 audit where we will then ask for the documentation again.
And I see that under the May 19th, 2022 entry for the timeline that's at the bottom of the page. There was a further request or stipulation for an audit with a 14-day deadline to provide the required documentation?
Yes, through the chair, that is correct. And it's 14 days because it is a mandatory document that you have to have. And so, granted, some of those like the billings and that information that supports your primary residency, we do give some leeway to a bit more time. But similar to a permission from the landlord, this is a document that is a must-have in order for you to even apply for a license. So therefore, we had requested for that documentation. And in our particular review of what was, so we had asked for that documentation with the shorter timeline.
Okay, and a copy of that audit notification letter for the 2022 business license, that's at page 68 under tab 7 in the materials. Is that right?
Yes. So the audit notification letters, this would have been the second one that Ms. Kochar would have received. And it's it require, and it's very similar, if not identical, to the one that she had received earlier. Uh, and and uh, and so she would have been familiar with what to submit. I know that she had some. Uh, through this request, we had discovered that she also has some difficulty obtaining the strata approval, which she had earlier. And so she had asked for an extension. And to her credit, she did submit it. But it was interesting that she hadn't received or had that available in 14 days. Once again, it's something that you should have had. The audit was dated back in May 19th. The license was renewed December of 2021. So technically, when you apply for that license, you would have had 5 months to have that document already in place. So that delay and request for delay also triggered another point of interest for us, wondering what's the difficulty there.
There was a request, though, for some more time, and eventually the required documentation was submitted. Is that right?
Through the chair, yes, that is correct.
In the interim, July 11th, 2022, we're on the second page of the timeline. There was a third complaint that was received through Van Connect, I assume, with respect to the unit. Is that right?
Yes, through the chair, that is correct. June 11th, I believe, was the date of the.
And I'm looking at
Yes.
page 96 under tab 9. This is a copy of that complaint.
Through the chair, yes, that is the complaint. And in this particular one, it states again that this individual or this unit does not have, the person that's running it is not the principal residence there. Once again, so this is the third complaint in relatively a short period of time. And both cite fairly important key aspects of being compliant with the short-term rental license. So once again, this triggered a very, it triggered a higher interest for us to pursue this matter a bit further.
So this being then a stage 2 audit, there were those additional components being an inspection of the premises and then a follow-up interview with the licensee, correct?
Yes, that is correct. Because of the third complaint, but also the second complaint and the fact that there was a delay in the documentation and just the general dialogue that we had going back and forth, we felt it warranted a further investigation of the actual case file. And so we proceeded on the path of an inspection and also interview audit.
Okay, I'm looking at the entry for August 2nd, 2022. It says that a property use inspector, that's a city inspector, F. Cho, attended to the premises and met with the licensee.
Yes, through the chair, that is a property use inspector that we use. That's another area of an enforcement compliance arm that I oversee. And so they work closely with proactive enforcement staff. And so Fiona, Ms. Cho, went on site on August 2nd. And the results of her visit, which includes pictures, which I'm sure we'll refer to later on, state what she found. And interesting enough, in this August 2nd comment, our staff noted what Inspector Cho found, but also when Inspector Cho spoke with Ms. Kochar, there were notations in her investigation file that stated that Ms. Kochar had indicated that she doesn't live at the unit, that she stays with her family in Surrey with the baby there. She had a 10-month-old, or she had a 10-month-old baby back then. It's older now, but and that dialogue and what we saw in terms of the pictures didn't quite coincide with what we anticipated.
Okay, the inspection by the property use inspector, what did the property use inspector discover?
Yes, if I can take you to page 97, the notes from the inspector on page 97 state August 2nd, 2002, 22 compliance inspection, suggested time, and it says RO, which is the resident. Ms. Kochar was present, and she stated that that she, her husband, and her 10-year-old, but it should be 10-month-old baby live with their family in Surrey, and that they do not live in this unit. And then she states the other information in terms of what she found. And if I can take you to photos of starting at page 98, these are photos of a 2-bedroom unit in Kiefer. If you look at page 102, for example, the refrigerator, it shows that it's empty, like it's virtually empty. And I know Ms. Kochar has indicated the reasons for that, but it is something that we note, and it's something that we see commonly for suites that are very highly, virtually exclusively used for short-term rentals. If I take you to page 103, the cupboards also indicate very little household or regular household items, similar to what you may find in a hotel setting with a kitchen unit. And then 105 is similar, where we have other cabinets. 106 is a storage unit. We see very little storage there for personal items. And then 107 is a bathroom. 108, 109 are closets. 110. All these units, looking at these and having a 10-month-old baby, I've raised 3 children myself, and I know that it's virtually impossible to not have any baby items in the house, somewhere in the house. And we didn't see any references to that. I know Ms. Kochar has stated some of the reasons why they may not be there, but for this particular unit, for what the inspector found, we felt it does not follow the definition the definition provided in the bylaw. So we felt this was very strong evidence, and also in support of some of the information that Ms. Kochar had shared with us, that this is not her primary residence.
If I can just maybe summarize what you've said, is that in the inspectors, in the course of the inspection, there was an admission by or by the licensee, Ms. Kochar, that nobody was living there, and essentially the inspector saw a condominium void of any personal effects.
Through the chair, yes, that is correct.
So what was observed by the inspector matched up with what the licensee had divulged to her.
Yes, and what the complainants had indicated multiple times, it was starting to lean very close to what was being indicated as the person does not live there.
Thank you. The next thing that happened, back to the timeline at page 6, was a phone audit meeting completed with A. Holmes, R. Wong, and the licensee. And I'm reading from that entry. Concerns of the city regarding principal residents were discussed. First, before we get to the details of that discussion, can you tell us who A. Holmes and R. Wong are?
Yes, through the chair, Alexandra Holmes is supervising coordinator, in our proactive enforcement area. She oversees all the enforcement staff that are there, the folks that do the investigations and whatnot. So Ms. Holmes will conduct the interview audits along with Ms. Claire Thompson, who's the manager there. She also does some of the audits. But in this particular case, Alexander Holmes led the interview. R. Wong or Ray Wong is one of the enforcement clerks, and he participates. We always have another individual that helps to document, but also serve as another point of evidence for that audit process.
Now, in the course of that interview, some information was divulged to city staff by the licensee. Can you maybe just summarize some of the high points that were relevant to the chief license inspector's decision?
Yes, through the chair, there are indications in there that talk about why she's being audited again, and understandably, I mean, she may not be familiar with the process, and she had gone through a documentation audit, but she had felt quite taken back by that, and some of that dialogue is identified in page 124, where she thinks it's quite ridiculous that we're looking at her again, and that she feels very targeted. And I hope I've been able to explain that that's not the case, that we are following complaints, and it's a standard process, and the information that we've gathered have triggered our investigative interest, and so it's through our code of conduct that we need to follow through on this. Some of the other interesting key points that, if I may raise, is she refers to in the interview, and it's captured by both individuals, Ray and Alex, that she refers to Unit 613 of 555 Abbott. Well, she refers to that because we asked that question about. We noticed that you also have another condo that is registered to you, and what do you do with that? And she goes to explain in a summary that she uses that, and might I add that this unit on Abbott is on the same complex, so it's like the next building to the place where she has a license for short-term rental, and this is a unit that she used to live at before she purchased 802. Now, she claims that she retains that location to use as another residence. She uses it for storage. She uses it for an office space for her husband. But one statement, or a couple of statements she's made, that if I can refer to page 126, about the middle, what are the plans moving forward with 2613? That's what Alex had asked. And she says, move back into our unit in the fall, supposed to go back to work, keep this unit as an office space, so on and so forth. We blocked off our Airbnb calendar. We don't continue in the fall. And earlier on, she states that she is semi-permanent in Unit 802 in this conversation. And if I can take you to page 127, near the bottom, she states, when we ask about the 613 555 Abbott, she says, we move out of 802 in mid-May. Fridge is not stocked because of COVID. We're just putting people at risk with the condiments, whatnot. Empty out the closets because PPLs, people are staying here. We use 613 for storage, also storage within the building, their stuff. And I don't know what you mean by nobody lives here, but not going to leave children, clothes for people to steal. And she continues to say that other Airbnbs don't do that. In the next statement, this is where we also found interesting. Semi-permanently move everything out, only rent space out chunks at a time, optimize summer months, so on and so forth. But once again, this indicates that she clearly lives somewhere else. She also stated before that she lives with her family in Surrey as well. So now, okay, so there's 3 locations where we think you might be living as a primary resident. And certainly the photos that we've taken, even though it's prepared for an Airbnb, she says, but then if you look at the bookings up on page 27, 127, that box and the rentals, if I take you through the box, you can see very clearly that on the first row, June, July, August, September, October, that is from 2021. That indicates the number of bookings. That's pretty much solid for those months. And then in 2022, in May, June, July, August, September, not so much because we canceled their license or suspended their license, but those 4 months are very fully booked. And it coincides with the fact that she goes and lives somewhere else. When an individual lives somewhere else, for these types of purposes, it triggers a very high concern for us that the compliance for permanent residency is not met.
Mr. Miyagi, if you could just tell us, and maybe I just missed it, where in the documents the rental days are cited for 2022.
Oh, so on page 127, on the top, they're not so much the dates, but they're the rental numbers. It's in a table. And then above that, you'll see it broken down to number of days. And so if you go to page 126, it starts there. And it says calendar dates received July 12th and July 22nd. So these are dates that we had asked for the bookings. And it states all the different booking, total number of days dating back to 2020. And we calculate very high in the summertime for multiple years in 2021 and also in 2022. And so our thinking, based on the information we receive, is that this unit is not occupied as a primary residence. It's likely left vacant throughout the year. It's left as a hotel, a seasonal hotel for these summer months, and then this individual lives elsewhere, either in Surrey or in this other unit that she retains. And of course, individuals have the right to retain as many units as you want, I suppose. But you also have to then wonder if you should be doing short-term rentals as well, because this kind of behavior goes against the spirit of the bylaw, which we all know is that the housing impact in Vancouver is at a critical point, and as many rental units that are possible to be used is what the spirit of the short-term rental bylaw is. It's not intended to be run like a hotel for a big chunk of time. And this individual is also doing this, not going to Florida for the winter or not going to school in Europe and vacating for those reasons. But this individual works in Vancouver, has another residence a couple of feet away or in the same complex, and also has access to another residence in Surrey as well. And so through the interview audit, those were the situations that we came to help make that conclusion for the chief license inspector.
Those numbers that indicate the days of booking for short-term rental purposes on page 126 and 127, where do those come from?
Those come. Those are. They should have been provided by the license holders. So I believe Ms. Kochar had provided this information, or most of it. We also have a process through a software that we use that helps us calculate the bookings as well. And through the two pieces of information, we come up with these dates.
Part of the document requests during the audit process that the booking calendar is provided. Is that right?
That is correct.
So these numbers on page 126 and 127 reflect the booking numbers for the unit.
For 2020 and 2021, they reflect the information that was received in the document audit in 2021. So when you refer to these pages, they're not numbered, but you see the in page 31 and so forth. Those are calendars dates, but they go up to 2021.
That's
And
for the earlier audit, though.
that's correct.
At page 127, we have 2022 dates.
That's correct.
Refer to those starting at page 127, May 2022, and it indicates how many total days there are. So 10 days in May, 22 days in June, 25 days in July. Those are the number of days in each of those months that were booked for short-term rental?
Yes, that's our estimate, if you will. It's based on the number of rentals, which is 6 rentals. So if we look at July 2022, 6 rentals, which means 6 individual bookings that when you calculate all of them come up to 25 days.
And those figures came from the licensee during the document requests for the 2022 audit?
Yes, they should have come from the document request in the second audit, which I think there is information in here that goes back to 2022. That information isn't quite clear in terms of how to interpret that, I'm afraid. So we also use, it's called host compliance, and there is a tab, I think, back in page 206 that in the lower right-hand corner, it shows the number of documented stays, and it reflects, for example, if you look at page 207, and if you look at anyone, it'll say like 3 documented stays on August 2022. So we take that information, documented stays reflect a number of nights that were being booked. And so we take that information and correspond it with the information that the individual has provided.
And the numbers then that are on page 127 are those numbers?
We believe those are accurate.
Okay. So I'm just looking at the notes on the prior page, 126, about halfway down just before beginning with rental days from 2020. It looks like these are the notes of one of the 2 interviewers.
Yes.
And you'd read some of these, and I'm just starting sort of a third of the way down. Alex, this would be Alexander Holmes asking the question, what are the plans moving forward to 613? That's the rental apartment that was disclosed in the course of the interview. Is that right?
Yes, the 555 Abbott. It was also provided in the ICBC history, moving history. And so in that initial document information, that address was on there. But through our investigations and through the interview audit, we were able to ascertain that they still keep that unit. It's a rental unit for her, but they still keep the unit and then use it for these purposes. And then also it says later on, it says that she lives in Surrey as well. Before.
So at the time of the interview, there was an indication that right now living in 613, before was in Surrey. We haven't been at 802. Before mid-May was in 802. So from that, the understanding combined with the notes of Alexander Holmes was that that the licensee had not been living in 802 since mid-2022, correct? Mid-May.
Mid-May.
2022.
Through the chair, that is correct.
Okay, and if I look at the dates then on page 127, it looks like the short-term rental numbers line up with that. 10 days in May for short-term rentals is about half the month, correct?
Through the chair, yes, the booking history from 2021 and 2022 coincide with that behavior.
And more or less for June, July, August, say 80 to 90% capacity booking for short-term rentals on those months.
Yes, that is correct.
And as of the interview, the interview date again was
Was
August
August 18th. Yes.
And for August, it looks like there'd been 19 total days, so it would be the entire of the month had been. So
Yes.
at the time of the interview, there was the admission that they weren't living in the unit; they were living in the rental unit, or the licensee was living in the rental unit, and it hadn't been occupied since mid-May.
Through the chair, yes, that is correct.
Okay, I take it then that there was a conclusion that it wasn't being used as a principal residence.
Yes, the information that we gathered led to that conclusion for us.
All right, so the decision was made then with respect to the suspension of the license?
Yes, so after the conclusion of the audit and then looking at all the information, having discussions with myself, the chief license inspector, and all the investigators, August 31st, a suspension letter was issued by the chief license inspector stating the totality of the information obtained leads us to believe that it does not support that this is your primary residence.
All right, and that was communicated in a suspension letter dated August 31st, 2022 from the chief license inspector to the licensee.
Yes.
Sent by registered mail. That's at tab 14 of the materials.
Yes, tab 14, page 192.
192, thank you. And just then moving on to the following tab, 194, page 194, tab 15. This is a warning letter dated September 20th, 2022. Can you tell us what this letter is all about?
Yes, through the chair, we frequently look for compliance after we issue a suspension letter. And in this particular case, we had forwarded the letter August 31st. We monitored the activities on the website, and we have discovered that the listing was still up and that it was being advertised for 30 days or more, which is considered a long-term rental. And we did not have record of Ms. Kochar having a long-term rental license, which is a requirement when you're renting long-term. And so therefore we sent her a warning letter saying, please cease and desist this activity until you get a long-term rental license. And interestingly enough, if an individual rents or seeks a renter for long-term rentals, that's another firm point of confirmation for us that an individual that rents something for full time like that long term, you wouldn't be able to do that if that's your primary residence. If you live there full time, how can you rent this for full time as well? And that's another point of information that we felt was very important to include in this evidence package, and it supports the decision that the chief license inspector made about this location not being her primary residence.
Thank you, Mr. Maggi. I don't have any further questions. Is there anything else that you want to add?
Through the chair, I believe all the points were covered. And I would like to once again note that this particular building, this Kiefer, 188 Kiefer, or 183 Kiefer, is a high non-compliant building. I'm not saying that she's necessarily because she lives there, but we have a lot of cases that generate out of that building as well. So we do pay additional interest and attention to that location. So part of what we go through, uh, we're fairly confident that the information that we provided does reflect the decision. And for the spirit of the bylaw that's intended, we do feel that this location is not meeting that particular um, uh, intent.
Thank you, Mr. Manager. Those are all of my questions.
Thank you. Panel members, do you have any questions for the witness? I mean, this would be for Mr. Crabtree. Oh, sorry, Koji, first name. Sorry. Miami? No questions? There's nobody on, right, that's fine. Then we can move right along.
Councillor Fry raised his hand. I think he may have a question.
Yeah, thanks, Robert. It's logged me out of the Creston. A question for Mr. Miyagi. The complainants, since they're redacted, are these? I'm curious. Are these different complainants, or is this one complainant that had reported this on multiple occasions?
Through the chair, the complaint information is redacted because this is a public document, and the how we treat complaints and complaint information is protected in the Privacy Act, and so because this document is public, we had to redact this. I am unable to disclose that information in terms of who or what, or if there's the same individual that has complained. What I can add, though, is that these complaints came from the building, and so it is a resident or somebody that lives there, which adds a bit more credibility to the complaint.
Sure. Yeah. No, and I'm satisfied with the body of your evidence. I'm really just curious as to how these complaints work, and you know, honestly, just even outside of this particular case, how we ensure that they're not just sort of personal beefs or what have you. But I'm satisfied with the rest of the information, the evidence you provided. So I'm fine with these questions at that. Thank you.
Okay, thank you. And I'm wondering if at this point now, unless there's any other questions, which I don't see any hands up on that, if the licensee, so Punir, Coacher, if you have any questions for Mr. Miyagi?
I do, yeah.
Go ahead.
Sorry, I'm going to be a little bit slow here because I've got a bunch of tabs open that I need to go through. So to start, in the opening remarks by Mr. LeBlanc, it was stated that a high volume of bookings was a reason for the city to deem it was not my principal residence. Can you please clarify for the panel what the booking percentage was and what you deem as high?
To me, Ms. Coacher,
Yes.
sorry, through the chair.
For Mr. Miyagi. Yes. Co-Chair, can we just get some clarification? Is that question directed at Mr. Miyagi?
Yes, it is directed at Mr. Miyagi.
Okay. Sorry, so to just to get clarification, are you wanting to know what the percentage is? Or are you wanting to know, or maybe if I can get you to ask that question again?
Maybe you could start with what you deem as high, a high number of bookings. You referred to that a few times in your statements.
Yes, through the chair, high would be if it's completely booked for the month. If it's, I guess, anything over 50%, which is not necessarily defined in the bylaw, but from a reasonable standpoint to determine if you live if an individual lives there full time or not, that those numbers do fluctuate. But from a reasonable standpoint, the numbers that you've presented or that we have for your residents is considered high.
So to clarify, high to you is 50%,
There is no set number.
but you referred to the term high, so I'd like to define what high means, because it can just be arbitrary otherwise.
No, your numbers are high.
What are my numbers?
So we stated those in the on page 126.
So on page 126 and 127, it says for the initial audit, which you claimed was a stage 1 audit, there was a total number of 115 days rented, which is 32% of the year. You mentioned that 50% was high. 32% is well below 50%. Can you please confirm?
I stated that 50, through the chair, I stated that 50% could be considered high. What I'd like to state again is that your numbers that you provided are considered high from an investigative standpoint.
Okay. So 32% out of the year for you is high. And I'm sure you do this a lot in your line of work. When you audit other individuals or licensees that you deem it is not or not compliant, or this may not be their primary residence, would you say that 32% is an average of how many bookings they typically have in a year when it is not their primary residence?
Through the chair, I can't state those numbers. I don't have those. What I can state is the totality of information provided leads us to take the numbers of bookings into consideration. And as I reiterated before, we believe the numbers that you provided for 2022, which is the license that's in question, is high.
Okay, so just to clarify, for 2021, it was 128 days, which is 35% of the year. And for 2022, it is 115 days, which is only 32% of the year. And from my understanding, you deem that as high, even though it is not 50% of the year, which seems to be some sort of requirement. As a matter of fact, I'm pretty sure our strata even received notes from the city of Vancouver, which said 6 months is the average that the city looks at. If it's booked more than 6%, they deem it to not be their primary residence. Is that correct?
Through the chair, no, it's not correct. That's not what I said. I said the totality of information that's provided. You're going with the annual average of 365 days. We're looking at the totality, the concentration, the circumstances that you're under. We look at all those kind of things. And given the information that you provided, we consider those numbers high.
So I'm referring to the opening statement in which it was stated that there was a high volume of bookings, quote, high volume of bookings, unquote. I'm not referring to why my license was suspended. I'm not referring to the totality of the information. I'm referring to that statement that was made in the opening remarks, which it said it was a reason for the city to deem it was not my principal residence. So I'm only speaking to that one reason, not the totality of the information. So can you please let me know whether you deem that 32% of the year, 115 days out of 365 days, is a high number of bookings?
In your context,
Yes
it
or
would
no?
be in your context, it would be high.
And my context is what?
It's concentrated in that period of time.
Okay, so to your knowledge, you don't find that some licensees find it most beneficial to rent their unit or do short-term rental in their unit during busy season, which it might be ski season in Vancouver, or it could be the summertime in Vancouver.
Through the chair, I can only speak to your context. And as I mentioned before, it is considered high. An individual that rents every weekend may have the similar numbers as perhaps what you have in totality, but in that context, that may not be considered to support a non-residency part of totality. In your context, it's concentrated, and so therefore, I believe it is high.
Right. Okay. So referring back to the definition of principal residence, can you confirm that I meet all of these following requirements? I will ask them one by one. Documentation related to billing, identification, taxation, insurance purposes. Can you confirm that my income tax returns are filed at 802 183 Kiefer Place?
I could confirm that that's the information provided, yes.
Can you confirm that my driver's license is issued at 802 183 Kiefer Place?
I believe that is the case, yes.
Can you confirm that my vehicle registered with ICBC is registered at 802 183 Kiefer Place?
That is what you provided, yes.
Can you confirm that my utility bills are under my name at 802 183 Kiefer Place?
And once again, that is what you provided, yes.
Can you confirm, as a part of the definition, that I am paying bills, receiving mail, and generally the dwelling unit within the residential address used on documentation related to billing, identification, taxation, and insurance purposes, including without limitation, income tax returns, medical service plans, et cetera, et cetera, et cetera, I am in compliance of all of that?
Through the chair, no, I cannot confirm that you pay those bills out of that particular residence. It indicates that that's what you use to self-declare that that's what the address you want to be sent there. It doesn't necessarily mean that you actually do those activities there, so I cannot confirm that.
I'm not sure I understand. Can you please clarify with what you mean by you're not sure I do that there? Do what there?
Sorry, you're asking me if I confirm that you pay those bills there from that residence is what I understood your question to be. And respectfully, I cannot confirm that because I do not know where you pay your bills.
Okay, can you confirm that I receive mail there and it is generally in the dwelling unit where the residential address used on documentation related to billing, identification, taxation, and insurance purposes, including without limitation, income tax returns, medical service plan documentation, driver's licenses, personal identification, vehicle registration, and utility bill. And for the purposes of this bylaw, I only have one principal resident unit.
All I can confirm is that's the address that is shown on the bills and the documents that you provided. I can also add that an individual could place that address anytime without verification from the companies, but what you provided, I can see that you've used that 802 address. I can't
Okay.
confirm whether you get mail there because I don't live there. And so I'm sorry, I can't answer those questions to the extent that you wish me to.
Okay, so as a part of this audit, what is the purpose for the city to obtain these documents if you're telling me that you can't confirm that information anyway?
It's provided in good faith, and the totality of information is then taken into consideration in terms of what we as investigators think is, if it is provided in good faith or not.
From the definition, can you please specify what specifically I did not satisfy for the city?
I believe we explained this through the questions that Mr. LeBlanc had provided. It's stated in the letter by the Chief License Inspector as well.
Okay, I can go back to the letter and read it again. Give me a second. So it says that I did not satisfy. So it said the information received from the community, the compliance inspection information from the meeting, the information did not support that 802-183 Kiefer is my principal residence. Can you please clarify what specific information you received did not satisfy it as my principal residence?
Through the chair, the questions that Mr. LeBlanc took me through, I believe more than clearly identified what we felt was relevant.
So you had stated that you feel that I use 802 Kiefer, 183 Kiefer Place. I leave it empty for the remainder of the year and only use it for the summer months. Is that correct? That's why the city deemed that it was not my primary residence?
Through the chair, once again, it is the totality of information. It's information that you provided, information we collected, information that we've gathered and looked at. All the information that we were explaining through this hearing just prior to you questioning me is what we felt was relevant.
Okay, so if you determined that 802 183 Kiefer Place is not my principal residence, then what has the city determined is my principal residence? Or has the city determined that I don't have one?
Through the chair, that's outside the realm of what the city needs to determine. We're trying to identify whether your short-term rental license application meets the compliance requirements of the bylaw. So it's not our position to state where you live.
Okay, so you don't believe that, or you have not found that 613 Abbott Street is my primary residence, or somewhere in Surrey is not my primary residence. Is that correct?
No, that's not correct. What we're saying is that 802, 183 Kiefer Place is not your primary residence, as per the definition of obtaining a short-term rental license. We don't
So
think
where does
we
it
don't
say-
think you're in compliance.
Okay, so when you came to that conclusion, as a part of your investigation, where is it that you deem that I stay for 8 months out of the year?
Through the chair, through what you've indicated, you stated that you stay with your mother in Surrey, and we've been through this before. You also indicated in the audit that you live at 613 555 Abbott Street. That's what you've indicated. We've indicated that in this proceedings.
Okay, I'll get to that in a minute. To the best of your knowledge, do I own any other properties besides 802 183 Kiefer Place?
I only know the information that's in the evidence package.
Is it typical for the city as a part of their process to do a title search on any other addresses that they have on file for a licensee?
Through the chair, that is not uncommon.
So did you do a title search on 613 Abbott Street?
We did a property, well, the information that we provided that we did is in the package.
It's a yes or no question. Did you do a title search for 613 Abbott Street?
We did a property report. So if it's not in the package, then I would have to assume no, it's not.
So to confirm, you did not do a property search, a title search for 613 Abbott Street.
If it's not in the package.
On August 31st, it was determined that the audit, August 31st, 2021, it was deemed that the audit was completed. The initial stage one, the audit that you referred to as stage one. When does the city decide or determine, what's the process for the city to determine whether a stage one or a stage two audit is necessary?
As indicated earlier, we have various means to look at that. A complaint could trigger that. We could randomly select one. Um, uh, the bylaw states that that the city has the right to look at those or ask for documentation anytime, and so therefore that's what we do.
So when you received the first complaint, which is on sorry, it's not easy having this all just electronic. So on March 27, 2021, the city received their first complaint that the unit is not the primary residence. Typically, when you receive that sort of complaint, would you conduct a stage 1 or a stage 2 audit?
We may.
That doesn't answer my question. Would you like me to repeat my question?
Well, you asked typically, do we do that? And our response is we may.
No, my question was typically when you receive a complaint that a unit is not somebody's primary residence, would you conduct a stage 1 or a stage 2 audit?
And I guess the response is it depends on what we deem as what we need to look into. Complaints certainly trigger an investigation, and then as we go through that, it may lead to a stage 2 audit, interview audit. It may end at interview or a document audit at stage 1. We follow the bylaw, and we're very careful how we follow the bylaw. And so I'm not sure if you're thinking we're targeting you. Is that where this is going? Maybe I shouldn't ask these questions. So I'll just leave it to just to say we follow the audit or the bylaw.
So, based on the information that you received as well as the complaint, what made you determine that a stage 2 audit was not required in my case?
In 2021?
Correct.
So we received the information, and at that time, I can't speak for the investigators. I'm not at that ground level, but they felt that was satisfactory.
Can you confirm what it was that they felt was satisfactory?
I'm sorry, I just stated that I'm not sure. I'm not at that ground level where they do these reviews, and so they must have felt that what you provided was satisfactory at that time.
Were you not provided the information or the file for that audit?
It's a document audit. We do many of those. We do thousands of those, and so I don't see each one of those. The ones that are elevated to me are in these circumstances where we have situations where we go through an interview audit or we suspect that there's no compliance.
So, as a part of this audit evidence package, you refer to the 2021 audit. So, if we're referring to that audit, why have we not gathered information about that audit?
Sorry, the 2021 document audit, is that what you're asking?
Yes.
And are you asking why we didn't go further in that particular case?
No, you mentioned you're not familiar with that audit. I'm trying to figure out what it was that um, whoever was conducting that audit, they obviously deemed that I satisfied um, that this 802-183 Kiefer Place was in fact my primary residence. So I'm wondering, are you familiar with the notes of that file where the auditor for that or whoever was collecting that information, why they deemed that no further investigation was necessary? Because it is a complaint about my primary residence. It's no different than the complaints that are received later on.
That was your first complaint. we trigger multiple complaints as a point of interest. In your particular case, perhaps you were lucky. I don't know the details of that, so I can't speculate.
So are you stating that I was lucky because there are loopholes in the city's audit process?
No, I'm
How does
not.
how does luck play into this?
No, I'm not.
So can you please clarify what you mean by I was lucky?
I said perhaps you were lucky because the
Can you
point I
please
made is that
clarify
I
what
do
you
not
meant by
know to the detail of each document audit. We do thousands of these. We have over 3,000 license holders, and we have many applications that we review. So um, you have to understand that, and I hope you understand that not every piece of paper comes across my desk.
I know, I'm not asking about every single piece of paper. I'm referring to my hearing, and my hearing has the 2021 audit report and audit documentation, and we've referred to the audit in 2021 many times in my specific hearing. So obviously, I would like it if you were informed on the 2021 audit process. And I'm just going to conclude here that you think in the 2021 audit, I perhaps got lucky. Can you please confirm?
No, that is not what I said. So no, I'm not confirming that. I am familiar with your 2021 audit because it is part of a bigger uh, process here. So yes, of course, I am familiar with that. If you're asking if I was familiar at that time that it was done in 2021, no, because we do thousands of those. And so it would be unrealistic for me to look at every document that comes across my desk.
I will clarify for you. I never asked whether you were familiar with my file at that time. I'm asking if you're familiar with my file present day.
Yes, of course I am.
Perfect. I'll ask my questions again then. Can you please confirm why the inspector or the auditor in the 2021 audit, A. Menzie, I believe his name was, what was his reason for feeling that I satisfied the primary principal residence
I'm going
bylaw?
to interject with this question. At this point, we've been over this territory a number of times. The question is causing Mr. Miyagi to speculate as to why somebody else did something else, and that's not a proper question. Mr. Miyagi's already said he has no knowledge of why the
Yeah,
audit
he
was
also went
passed.
on to say that I just got lucky. So
Again, I think he's speculating, and that's an improper question.
okay, so all right. So just so I understand correctly, nobody knows why in 2021 my principal residence status was satisfied. Is that correct?
No, that is not correct.
Okay, can you please tell me why it was satisfied? Why this auditor deemed that 802183 Kiefer Place was in fact my primary residence?
Again, the question asks for speculation on the part of Mr. Miyagi. He's already answered that question. Doesn't know.
I'm confused. You're saying something else, Mr. LeBlanc, and Mr. Miyagi is answering the question as if he knows the answer. So I'm a little bit confused.
Maybe I'll ask for the chair to direct what happens with that particular question.
Okay, that question has been asked. Yes, excuse me. That question has been asked of Mr. Miyagi. He has confirmed an answer to you, which is at that time that file was one that there's many thousands of those kinds of files, and that is not something that has escalated to the point of his involvement, which is what is happening now. So I will confirm that Mr. LeBlanc's point, which is that you have received an answer to your question that is may not satisfy you, but it is an answer, and it is the only answer at this point in time. You can, repeat the question is not going to get you a different answer, so you should move on with your questions.
Sounds great. I just want to make sure that the panel understands that Mr. Miyagi thinks that I just got lucky with that first audit. So I'll change my question back to, can you please clarify what the process is of determining whether a stage 1 or a stage 2 audit is required? Because, or maybe you could just clarify for me, is it true that a stage 2 audit is triggered when more than one complaint is received?
Mr. Biaggi?
Yes, through the chair, in your case, yes.
In my case, yes. Okay. So when when a second complaint is submitted for any license holder, a stage 2 audit will automatically be uh, conducted.
Through the chair, that's not what I said.
Okay, so can you please clarify what the city's process is on deciding whether a stage 1 or a stage 2 audit is required?
Through the chair, I've been through this before. We look at the totality of the information that's provided to us. And so when we look at, in your particular case, there was enough concern for us to go to a stage 2 audit.
Can you confirm what the concern specifically was at the time that the stage 2 audit was conducted, was commenced?
Through the chair, I believe we covered all that through the questioning from Mr. LeBlanc.
Do you mind repeating it? I don't remember that information.
Madam Chair, do we need to go through the whole proceedings here?
No, I don't believe so. Yeah, we did actually cover those questions. It's absolutely true. And at the time that we were we were proceeding with the detailed timeline and events that happened, in this particular related to this particular hearing. So actually, if you could just uh, focus on requirement or questions that may result in new information or information that you didn't understand, that would be a better focus. Thank you.
Sure. When you received a complaint that I did not have Strata's approval or the landlord's approval to operate a short-term rental in that unit, how would you say, in your professional opinion, somebody would be aware of that sort of information unless they were privy to private and confidential information about an owner?
I'm sorry, I'm not clear what you're asking. I don't know if you're asking me to speculate my professional opinion. I'm not sure. Maybe if you can, I'm not sure what you're asking.
Maybe you can just reframe that question. It might be helpful.
Sure. The complaint that was submitted against me was that I don't have Strata's approval to operate a short-term rental. Now, I'm just trying to understand why anybody or how anybody would have that information about me. It's very personal and private. So I believe that somebody would need to be in a place of power or privy to be able to have that information. Now, I've been told that the Strata Council works closely with the city to let the city know whether people are in compliance in this building. So I'm wondering, and I know you can't disclose, I guess you can't disclose any information about the complainant, but as Mr. Fry pointed out earlier, there are a lot of beefs in this building because you have a large number of a group of people that want that authorize, and it's been voted on many times at our AGMs whether short-term rentals should be allowed in our building or not. There's a handful of people that are very anti short-term rentals in our unit. So the city will probably receive a lot of falsified complaints about short-term rental operators because there is this vendetta that they're trying to get all of them banned in our building or prevent everybody from doing a short-term rental in our building. So anyway, there's no question there. So I'm going to move on to say to ask when you received all of the documentations, that were requested again, even though I had mentioned to Ray in my phone conversations as well as my email correspondences to him that I feel targeted and why am I being audited for a second time in a 9-month time frame. He had said that they received a complaint and you needed to satisfy whether it was my principal residence and you required additional documents, the same exact documents that I'd provided 9 months ago, except this time dated for 2022, which I provided. And then you also needed a letter from the strata, which I also provided. So I had satisfied the strata approval letter, the strata approval, which is what the complaint was. So after you deemed that the complaint was false and misleading and in fact incorrect, what made you decide that a further investigation was necessary? An audit had already been conducted and a city employee had already determined that 802-183 Kiefer Place is my principal residence. Then somebody complained that, oh, she doesn't have approval. You received that approval letter. You received all of the documentations about it being my principal residence dated for the new year. What was missing in the information that you received that caused you to further investigate?
So as I mentioned earlier, if there's that question in there, you did not have your strata authorization when you had applied, renewed your license. And so we asked for that information.
Actually, I did have my strata authorization letter. It's just that when you had asked for it again, you said that even though it's late in 2021 and it hasn't been 12 months yet since I received that letter, I needed a new one that was dated for 2022. That is why I did not have that license, and it should be in the email thread in the evidence between Ray and I. And you also mentioned earlier in your questioning when in your statements to Mr. LeBlanc that it triggered your interest, or you found it interesting that I needed an extension to obtain this strata authorization letter. Can you please clarify what you mean by that was interesting?
Yes, because you didn't have the authorization letter. The letter was dated June, if I recall correctly. You had renewed your license in December. Every renewal is considered a new license. In terms of when your information could be asked, your circumstances could change. So granted, it's a renewal, but it is a new license. And so the information is up to the city, and the city reserves the right to ask when we feel is important for us to know. And in your particular case, you didn't have that strata approval. You asked for an extension in obtaining that, and so that was interesting.
So on your website or in the bylaws or any rules that you have, does it state that every calendar year you require a new license, a new letter from your strata?
Through the chair, we follow the bylaw. The bylaw says if you apply for a license or if you receive a business license, it says here 14A, short-term rental accommodation operator shall provide documentation or records that demonstrate compliance to this bylaw to the chief license inspector upon request, including but not limited to. And it talks about documents for short-term rental that prove your principal residence as Section A. Section B states proof of strata authorization if the short-term rental accommodation is in a strata lot. You applied for a new license in 2022, so we follow the bylaw, Section 14B.
I'm going to repeat my question. In the bylaw, does it state that a new letter from your strata is required each calendar year?
Through the chair, I believe I answered that question. The bylaw states the city can ask for these documents.
Right, but does it state that a new letter is required? Because you deemed that, oh, at any call, any time that you felt it was necessary, you can call upon me and I should present this letter. And I did present a letter to you, except you felt that that one's from June 2021, so you wanted a new one. Where in the bylaws does it say that you need to present a letter dated for every new calendar year?
Through the chair, that's not what I said. And if I can add, the individual's being argumentative here, and I'm not quite sure how to answer some of these questions. I've already stated the responses that, in my opinion, cover her question.
Okay, perhaps you can move on to another line of questioning if you have one. I think that'd be appreciated, Ms. Kocher.
Sure. I'm just going to end that by Mr. Maggi said that it was interesting that I needed an extension. I needed an extension to obtain that strata authorization letter. Nowhere in the bylaws, nowhere on the city's website is it clear that I need to get a new license every time I apply for a new letter every time I apply for a short-term rental license that's dated for that calendar year, which is why I didn't have it and which is why there was a delay. Also, if you refer to the email thread between Ray and I, you'll see that my strata was very, very slow in responding to me. And I even provided an email thread between me and my strata management company to prove that they weren't responding to me. And I had emailed them 3 different times. So that's what the reasoning for me not being able to meet that 14-day deadline was.
Through the chair, it does say, and I stated this earlier, it's very clear on the website that you must have all your documentations w- ready to present when you apply. It says that right on the website when you apply. So it is on there. And the strata documentation is one of the documents that says you have to have. So it is on there. So when you apply for your 2022 license, you should have had that.
And I did provide you with the strata approval letter. You just deemed that it wasn't valid for that year.
Well, you provided a 2021 dated one.
It was less than 12 months old, yes.
It was for the 2021 license. This is for the 2022 license.
Right, and all I'm saying is that it's not clear on your website or in the bylaw that a new letter is required from Strata every calendar year. Now I know, and I will make sure that anytime I apply for a new license, I get a letter from the Strata. I'll move on.
Does you have further questions?
I do, yes.
Okay.
You mentioned that it triggers your interest when you receive multiple complaints. How do you determine if a complaint is viable and it's not a disgruntled strata council member, a neighbor, or someone that doesn't want anyone to do STR in the building?
Through our investigation, we
You investigate the complainant?
no, through the chair, we investigate what the complaint says.
So to confirm, if I filed a complaint about my neighbor every 3 months, can you confirm that every 3 months the city would investigate them?
We would investigate, as I mentioned before, we respond to every complaint that's received to us. We look at it and then we follow through to the best of our ability.
So your answer is yes, you would investigate every 3 months if I filed a complaint about my neighbor. Great.
Sorry, is that a question?
Nope. So once the city confirmed that the complaint was in fact incorrect, and as a matter of fact, I did have Strata's approval and I was allowed to operate STR in my unit, why was the audit not completed at that point? Especially since an audit of whether the unit is my primary residence or not was just completed a few months prior.
That is part of our choice to investigate further. And in this particular case, we felt that it was important to follow through on an interview audit.
So can you please clarify what it is that helps you make that decision?
Yes, as stated in the letter, it's up from the chief license inspector. It's the totality of the information.
The totality of the information, to clarify, was A, I am in compliant and the complaint was invalid about whether I'm allowed to operate or not. And B, my primary residence had already been confirmed a few months prior by a city member. So with that information, I was compliant in both of those complaints. You still felt that further investigation was necessary, correct?
Through the chair, we noted the on-site I was going to say investigation, the on-site visit by our inspector. It's the totality of information, and there's things that you've indicated about you not living there. As I mentioned earlier in the cross questioning by Mr. LeBlanc, all this has been answered. So.
You're actually not answering my question, because I'm not referring to things that were identified as a part of your audit once you had already decided to go further. I'm asking why it was that you went further, because as far as I can see, all of the information provided to the city should have satisfied the complaint and the principal residency, because it was a city member, somebody that had conducted an audit, already felt that it was my principal residence. They did their job as a part of the first complaint, and I had satisfied the second complaint, which was that I wasn't allowed to operate. The Strata hadn't given me permission to operate. So I had satisfied both of those complaints. So what was it that was left that the city needed to figure out?
Well, as I mentioned earlier, the inspection triggered questions. The comments that you made at the inspection triggered questions, which then were verified in the audit. The duration of it's all in the evidence package, and so, Madam Chair, I don't know if I need to go through this again.
I think that these questions do seem to be repetitive. So if you have another set of questions or a different question to ask, I encourage you to move to that, because I think the question has been reframed a number of times by yourself, and the same answers given. So I think moving to something new or a different set of inquiries you might have would be useful at this time.
Sure. Can you please tell me what the purpose is of a compliance inspection, which in my case was completed by Ms. Cho?
So sorry, the purpose of why do we do the inspection?
Yes.
Yes, so we want to see if you are compliant to the bylaw.
Compliant to the bylaw of whether it's my principal residence?
Yes.
Okay. If you can you refer to page 170? Second. Page 176. Let me know when you're there and I'll continue.
I am there.
So in an email from Fiona Cho, who is the compliance inspector, it says in the email, "Hi Puneet, further to our telephone conversation, please be reminded that the bylaw compliance inspection has been scheduled for Monday, July 25th, 2022 at 10:30 a.m. For your reference, I will be looking for the following: fire extinguisher on every floor, if applicable, Unit 802 fire exit plan with contact information sheet and muster point, smoke detector, carbon monoxide detectors, no keyed locks or deadbolts on any interior doors, work without permit, if any. Bylaw compliance include but may not be limited to licensed bylaw, zoning and development bylaw, Vancouver building bylaw, parking bylaw, standard of maintenance bylaw, and noise control bylaw. Can you please show me where in Ms. Cho's email she mentioned that she was coming in for to determine whether I was in compliance with the primary, with whether this unit is my principal residence?
So number 6 does that.
Can you confirm which bylaw?
It's a licensing bylaw.
Okay. So in her inspection, can you confirm what the purpose is of taking photographs of the unit?
That's our common practice.
If it's your common practice, why is it that you don't list them out like you do? Hey, we're going to look for a fire extinguisher. We're going to look if you have a smoke detector. Why do you not say that they're going to take pictures? And why do you not state whether we're going to check to see if this is your principal residence?
Once again, we've indicated, Fiona has been very clear on point 6, that we look for bylaw infraction or compliance. That's what it states. How we conduct our bylaw inspection is up to us. So if you're asking why we didn't tell you in advance, that's not our, how we conduct our inspection is how we conduct our inspections.
But you do mention the need for all of the other items, like a smoke detector or making sure that there's no key locks. Hey, we're letting you know, make sure you don't have any work without permit there. But it's interesting to me that you leave out this one item where you're also checking to see, hey, is this your principal residence? I just find that very interesting.
Ms. Kojar, this is not actually closing comments by you. Some of the points you're making now may well be points you wish to raise as to what is interesting to you or not in your closing comments. This is specifically to ask questions, so I ask you to just focus on that, please.
Okay, sorry, my apologies. I'm not familiar with these proceedings, so I can save my comments for the end if that's how it works.
Yes.
Continue with my questions. Mr. Manji, can you confirm if the conversations are recorded as a part of the inspection?
The on-site inspection or
Yeah. Yes,
they're not recorded?
they're not recorded. So in her findings, Ms. Cho states that I have a 10-year-old, which is incorrect. And as a part of her inspection, she doesn't state whether I have keyed locks or deadbolts, but rather it refers a lot to a lot of my personal information. Can you confirm that that's in fact what this compliance inspection is intended for?
I'm sorry, I'm not clear what you're asking me. Are you asking me if Fiona made a mistake about the 10-year-old baby?
No, I'm asking whether you were wondering if I had a smoke detector in my unit, or whether that was of importance to you.
It's part of the inspection process. If Fiona states those items, then that's one of the things that she would have looked at.
They just don't include it in their findings? Or it's not important to be included in the findings?
I'm sorry, are you saying that you have a uh, fire alarm and she didn't mention that? Is that what you're asking me? Sorry for clarification.
No, what I'm asking is been given a very specific list of items that I need to ensure I'm doing in order to be compliant. But when I look at the findings of Ms. Cho, I see that some of the items are just not mentioned in the findings. As a matter of fact, there's a lot more information about my personal life than there is about the 5 items that she had listed uh, in her email to me.
The question again causes Mr. Miyagi to speculate as to why the note taker did or didn't include certain things in her report. He can't speak for the inspector.
Okay.
Do you have further questions, Ms. Coulter?
I do, yeah, sorry. I'm just trying to filter through my questions of where it might be causing Mr. Miyagi to speculate. So I'm just filtering through those. Okay. Okay, I think that's all I have for questions.
Okay, thank you very much. For that, panel members, do you have any question? Sorry. Yes, do you have any questions? Ms. Coulter? Or actually, first I should ask if you're going to call any witnesses or not.
Me?
Yes.
No,
Okay.
unfortunately not.
Okay, that's fine. Panel members, then, do you have any questions? That would be for the witnesses. No witnesses. Is there an opportunity then for questions of the panel members to Ms. Coulter? Is this not in this list of?
Maybe sometimes there's some confusion by the licensees as to when they should be saying what. I'll say this is that the witnesses would be required to give evidence that would be evidence that the licensee would like the panel to rely upon in weighing whether or not there was a reasonable decision by the chief license inspector to suspend the license. So if you have any evidentiary points, Ms. Kochar, that you'd like to put before the panel, then you should be giving evidence on your own accord. So you would be the witness.
Oh. Okay. I'm not sure I fully understand that. So I'm supposed to provide evidence on why it's my principal residence. Is that right?
Well, if that's what you want the panel to consider, then now would be the time to give that evidence as a witness.
Okay. So okay, I'm sorry. I'm not sure I fully understand how this is different from opening and closing remarks. So if I repeat myself, I apologize. Um, but I believe that I mean, to start, I reside at 802 183 Kiefer Place for majority of the year, as you can see in my calendar. We only operate a short-term rent. We only operate Airbnb and do short-term rental in the summer months, because it's a way for us to make a little bit of extra cash. And Vancouver is a really expensive place. to live, and I'm a new mom and I'm on maternity leave, so that's been really helpful in getting a little bit of extra money to help with the mortgage payments. Um, I can testify that I do not own any other uh, residences. I am not that well off that I have the luxury of owning and living in multiple places. Um, we moved into 802 Kiefer, 183 Kiefer Place, um, shortly after the pandemic. I believe it was in the summertime, um, because the rental market was becoming terrible. And so we decided to move into that unit. And at that time, um, my partner and I were both working from home, so we didn't know what to do as far as how we were going to separate our office spaces, because both of us take a lot of meetings. Um, so our unit probably did sit empty for maybe 1 month, not even probably. Um, sorry, when I say unit, I mean 802 183 Heifer Place. Um, and then my cousin Paul, who is actually our property manager, he said to me, "Hey, why don't you guys do short-term rental for a few months and see how it goes?" So because we had at that time 613 as well, which we get very, very cheap rent, we decided that, okay, well, sure, we can try to see how it works for a few months. But and then after that, we moved in to 802 183 Kiefer Place. So for timeline, we're looking at 2020. That's when, in the summer of 2020, that's when we would have moved into 802 183 Kiefer Place. We looked into subletting our unit at 613 Abbott Street. The reason we didn't give that unit up is because my partner's family lives in Ireland, and his sister has 3 kids, and she also lives in Ireland. So we have them come visit and stay with us for large chunks of time. Like I'm talking, more than a few weeks at a time. And we don't feel comfortable staying in the same place. So it made the most sense for us to keep that 613 unit at that time. And then as we went further on, my partner uses 613 Abbott Street. It's only a 1 bedroom, just to clarify. He uses that as an office space to conduct his work, and I stay in 802 183 Kiefer Place with our baby for the most part. And he also needs that space between not working at home with the child. I know, Mr. Manji, you said you raised 3 kids. I'm sure your kids wouldn't have been running around in the house while you were working. Doesn't make for a very good environment. So I don't know if that satisfies why we have 2 places. I also forgot to mention that my partner's uh, anyway, that's not relevant. It's fine. Okay, I don't know what else I should be saying. I also pay my taxes for at 802 183 Kiefer. I declare that as my principal residence. I satisfy from a tax perspective. I can confirm that I'm an accountant. From a tax perspective, 802 183 Kiefer Place is considered my principal residence, especially since I only own 1 unit. All of my MSP, my driver's license, my vehicle is registered for 183 Kiefer Place. And, just to clarify, it would be really bad for my insurance if I wasn't actually living at that place where my car was parked most of the time, because most of us are working from home. So that is also there. I receive and I pay all my bills out of 802 Kiefer Place. As far as I understood, and I know, I satisfied the principal residence unit definition and the bylaw to the best of my knowledge. to the best of my knowledge, I satisfied and I was very compliant in providing all of the documents that the city required. Um, I have many tiffs with Roy, our Strata president, who I'm sure is the one that's submitting all of these complaints because he can't handle, or he is very anti short-term rental because he's had a few of his own bad experiences with it. And you're absolutely right. There were quite a few units in our building that were operating short-term rental without being compliant, and they were causing quite a nuisance for other residents in our building. And I think that's why it became this. There was this fight became um, prevalent between pro STR and anti STR in our building, and I'm sure the city receives complaints for many other units in this building that also operate short-term rental. Um, yeah, I mean, I'd also like to say, I mean, the city's determined that 802 183 Kiefer is not my principal residence. I just don't understand. Um, I just don't understand how they could have determined that isn't. And it's like, in order for that not to be my principal residence, I would have to be living for a large chunk of time somewhere else. And I don't see what the city could believe that place could be. Um, so anyway, I would like to testify and be a witness for myself that I am in fact living at 802 183 Kiefer Place, and it is my principal residence.
Okay, thank you. Yeah, that's it for your. This is just you do get closing comments just so that you you understand that you were right. So there is this point where you get to sort of introduce or do opening remarks, but and you've said that you don't have any other witnesses. So I'm going to move to the panel members and ask if they've got any questions for you. Councillor Zhou.
Okay, so Ms. Co-Chair, so I just have one question. I think on August 2nd, based on the document, it says you said you and your husband, your child live with your family in Surrey, and they do not live at this 802 183 Kiefer Place. Is that right?
Sorry, can you tell me what you're referring to? What
So
page?
on page 6 or page there's I saw two places or page 97. So it says on August 2nd, you said yourself and your husband and child live with your family in Surrey, and they do not live at 802 183 Kiefer Place.
That
Did
is
you?
absolutely untrue. I don't know why. That's why I asked if that conversation was recorded, because I mean, she also thinks that I have a 10-year-old child. So I don't know why she said that I lived in Surrey. That is very false. I actually told her that that day, I was staying at that moment, I was staying with my mom in Surrey. But I haven't lived in Surrey since 2015.
Okay, that's all my question. Thank you, Chair.
Thank you, Councillor Zhou. Councillor Fry, questions?
Yeah, thank you. So now, from the definition, and now I appreciate you're trying to maintain that this is in fact your principal residence unit, which seems difficult to square. We define principal residence unit as a dwelling where the individual lives, makes their home, and conducts their daily affairs, which seems perhaps that this is not where you do your daily affairs. And the list of supporting evidence that has been discussed throughout this is really meant to bolster that. But on the sole premise that this is your principal residence where you do your daily affairs, uh, how do you explain your unlicensed long-term residential or rental accommodation um, warning letter?
Yeah, so the reason for that is our property manager, once we told him that we were suspended from doing short-term rentals, he assumed and changed it to 30-day rentals on his own accord. I don't have access to our Airbnb listing. It's managed by our our property manager named Paul. And so he had done that. When I received that letter, I didn't even know that our unit was listed for 30-day rental. So once I let him know, he removed that listing immediately.
But I don't understand, if it's your primary residence, how can he just give it away for over 30 days, and where do you go?
So at that time, as you can see in our calendars, we had decided that specific year just to rent out our unit for the summer months. So we decided on May 15th or early in May that, hey, like, the summer is coming up. It'd be good to make some extra cash. Why don't we try to do that short-term rental again, seeing how, it worked out pretty well over Christmas. So I'm pretty sure it was May 15th that we listed our unit on Airbnb, and May 17th was when the complaint was received. So we had told our property manager that to list the place and see how many bookings we get. And we had gotten bookings like pretty quickly for a lot of the summer months. And so we hadn't determined at that point what date we were going to move back into the unit. But I had mentioned even in my interview that it wasn't going to be later than fall. So by the end of September, once the busy season is over, we were planning on moving in.
So it really can't be considered, in fairness, your principal residence, though.
I don't know why that would be, because we're only renting it out for the summer months. So primarily for 8 months out of the year, we're living in that unit, conducting all of our business in that unit, conducting all of our daily affairs as per the bylaw in that unit. It's only for 4 months out of the year. Actually, we have the numbers, only 32% of the year that for 32% of the year, I can agree that if you were to only look at those isolated 32% of that time, it's not my principal residence for 32% of that time. But for the remainder, 68% of the time, it is my principal residence. I do conduct all of my daily affairs in that unit.
Yeah, okay. Okay. I mean, the spirit of the bylaw is sort of outlined, and I think that it's pretty clear. But thanks for answering the questions.
No problem.
Okay, that's it for questions from panel members. Mr. LeBlanc.
I don't have any questions. Thank you.
No questions. Okay, closing submissions.
I'm up. Am I up?
Yes, it's closing submissions by our council.
Thank you. There's been some mention of the spirit of the bylaw here. I'm going to ask that maybe we refocus it from spirit of the bylaw to the purpose of the bylaw. This entire scheme was created by staff and enacted by council several years ago to address a diminishing stock of long-term housing. The purpose of the principal residency requirement is that it ensures that any property in the city that's being offered for short-term rental accommodation is actually a residence in which people conduct their daily affairs and fall within that definition that is established in the bylaw. The licensee has indicated that she's confused how there's no explanation by the city as to where she goes, and there would need to be large chunks of time for which she'd need to be absent from her property. I think that's borne out by the evidence. The indication, and that's not controverted at this point, is that it was vacated in mid-May. By the time in August that the premises had been audited and a decision was made by the chief license inspector, it was still being occupied not by a principal resident. It was occupied by short-term rental accommodation parties on more or less a full-time basis. We still don't know when the parties move back into the unit. That wasn't provided in evidence, but there was allusion in response to Constable Fry's question that it was at least at the end of September, so well over a third of the year, whereby the resident vacated the unit. A principal residence isn't simply a place that you can move in and out of at convenience, treating it and perhaps other residences like musical chairs that you can stay in order to supplement your income. It is intended to be and to remain a full-time principal residence. That's not what's been borne out by the evidence. The decision of the Chief License Inspector that the licensee had not established to the Chief License Inspector's satisfaction that this was a principal residence, and the onus is on the licensee to establish that, was a reasonable decision. That information was available to the Chief License Inspector, and when that information was available, it still wasn't being occupied by the chief or by the principal residence. So I'd ask that the panel defer to the Chief License Inspector's decision, uphold the suspension of the 2022 license.
Thank you, Mr. LeBlanc. Ms. Kojar, it's now your turn to do your closing comments. You are on mute. We can't hear you.
Sorry, apologies. As for all the evidence that's been submitted, and as it's been mentioned earlier, I only operate short-term rental for a small portion of the year, and for the remaining of the time, I reside at 802-183 Kiefer Place. In the 12-month period of the initial audit, my unit was rented for 35% of the time. In the second audit for the 12 months, my unit was rented only for 32% of the year. I feel that the city has made many speculations and assumptions to conclude that 802-183 Kiefer Place is not my principal residence, such as not stocking my fridge and not having personal belongings in my unit during the compliance inspection. I was advised by our property manager that we should remove all items in the fridge as it's not sanitary, and guests want an empty fridge due to COVID fears. He also advised that we not keep any of our personal clothes and valuables there for two reasons. One, he will not be liable if they get stolen. And two, there's not enough closet space left for our guests if we leave our stuff in there. In my lifetime, I have stayed at many Airbnbs, and not at one place have I seen the host's clothes left in the closet. If that is the expectation of the city for them to believe that it's my principal residence, quite frankly, I think it's absurd. I'd like for the panel to consider whether they would feel safe and comfortable leaving their clothes and toothbrushes and extra pairs of glasses, jewelry, or accessories at your place if you had random strangers that you've never met before staying there. Would you leave photo albums full of your family photos, your baby's first photo shoot, your memories, all there for strangers to look at, take photos of, and potentially post on social media? My son took his first steps, said his first words, and had many sleepless nights in 802-183 Kiefer Place. We look forward to celebrating the holidays there, having our friends over, and continue to make memories in our home, 802-183 Kiefer Place. It is, in fact, my principal residence by every means. If we're worried about the housing crisis, I think we should also have more faith in the empty homes tax and vacancy taxes, which I can assure you I cannot afford to pay. I don't know what my future plans are with regards to short-term rental. I don't even know if I want to continue, as seeing it's been such a headache in the past few years, and I'm tired of having this vendetta with my neighbors. As I stated in our interview, our plan was only to operate short-term rental for the busy summer months so that we can make a little bit of extra cash. Forgive me for doing so. I didn't know that wasn't allowed. I'm here today to get justice, and I'm here because the city wrongfully suspended my license, and I want the city to be held accountable for this decision. That's all.
Thanks, Ms. Kojar. Panel members, it's now up to you if you want further discussion or move to a decision with comments to that. I'll look to see if any of you put yourself on the list for discussion. Just 1 second. Councillor Fry, go ahead. Councillor Fry, I think you're on mute.
Apologies. I did submit a motion to uphold the license inspector's recommendation to suspend the business license.
I'm just going to make sure,
Um,
just before you continue, let's just make sure that that is projected onto the screen so that it's available for Ms. Kocher. Yep, it's up on the screen now. Okay, go ahead, Councillor Fry.
Yeah, I just want to reflect that I do sympathize with um, Puneet Kocher on how this would feel, personally upsetting. But this is the bylaw as we've written it, and it really does require this sort of principal residence component. And I do feel satisfied that the evidence suggests this is not actually a principal residence in the spirit of which it's been written. And I also do want to just, reflect, and it's not necessarily germane to the specific case, but we get a lot of complaints from that particular part of town, Forenza, Paris Place, all in and around Kiefer and Abbott there, and really horrendous complaints. So um, for the folks who really are principal residents of those buildings, we hear from them, and we hear how disruptive the constant stream of Airbnbs can be. People who are just visiting there and don't have that sort of investment into living in the units, and that's not a reflection on the owner in this case, but it's a reflection on the guests, and that can be super frustrating. So I really do appreciate that folks are frustrated by um, scenarios where the spirit of the bylaw here is not being upheld, and in fact the actual specifics of the bylaw are not being upheld. And I think the argument sort of falls apart when we start looking at the shifting to long-term rental, and really the photos that we see. And I certainly recognize that obviously you wouldn't want to keep your really personal stuff in plain view for guests, but our staff and our investigators are pretty adept at kind of identifying how people who actually live in their primary residence kind of can keep things sequestered in an appropriate way to keep them private, but you can still tell. And I've seen enough of these evidence packages to sort of see the difference as well. So I'm sorry to the applicant that you are going to lose this revenue generator, but at the same time, you still have a fantastic home in downtown Vancouver and a great place to raise your kid. And I hope it continues to be your home and your primary residence. And who knows, maybe you can reapply for a short-term license in the future, and with it as your principal residence when you're off on vacation or something to that effect. That's
Thanks.
it.
Thank you, Councillor Fry. We're going to need a seconder for that motion. Councillor Joe, thank you. And Councillor Joe, you are next on the speakers list.
Okay, so very quick, I think I'd like to echo what Councillor Fry just said. I do empathy for the situation for the applicant, but all the evidence is pretty evident. And I think the law is the law, the policy is policy. We have to follow whatever we have in the bylaw. And the comments from the applicant didn't give me enough, didn't convince me enough to overturn my decision based on all the evidence from the inspector. Thank you.
Okay, thank you, Councillor Joe. I will just add my comments at the end, and I certainly understand the frustration felt by our Ms. Kochar. I do understand from the point of view of having, as you said, stayed in many different B&Bs around the world. I too have stayed in many, but other places have different laws or rules or policies around it. And the reason why Vancouver is different, and we are one of those unique jurisdictions, is because we have such an incredible housing crisis in this city. And it was recognized by surveys just how many, especially in the downtown part of Vancouver, how many homes, especially condos, were primarily left empty or used for as Airbnbs, but much of the year left empty at a time when people could not find places to live at all. So we did bring in the bylaw to enable us to only license places that are primary residences, and thus only vacated on a very short-term basis for a weekend or a night, but not for months at a time. And the consequence of our bylaw has been a return to the rental market of a phenomenal number of places that formerly had just been sitting empty for much of the year, which is the intent of the bylaw. So I understand your frustration, but just wanted to let you know why we are a different city in that regard, and the compelling reasons, which may be frustrating for you, but in the bigger picture have really supplied more housing into a much needed market. So I'm not seeing any other comments. Well, we've all commented, so I think we can move to a vote on this matter. Thank you, clerk. Oh, sorry, just 1 second. I don't see on the list, Councillor. No, have you, it's here, the motion, oops, it's gone. The motion should be on the front screen again if you don't. It was emailed and it's, okay, I'm going to read that so that it's clear that the business license hearing panel suspend the 2022 business license issued to Puneet Kuchar, the licensee, for a short-term rental accommodation at 802-183 Kiefer Place, the premises, on the basis that the unit is not the primary residence of the owner, as evidenced by the investigation of premises and the listings, and additionally, the owner's advertisement on unlicensed long-term rental accommodation in response to their short-term license suspension. So are we clear on what we're voting on? Great. Okay. Now, clerk, if you could move us to a vote. Great. That vote passes unanimously. So at this point, we've concluded this hearing, and I would ask for a motion to adjourn, please. Thank you, Joe. And seconder? Councillor Fry, you may be on mute.
Second.
Thank you very much. All those in favor? Great. Any opposed? This hearing is adjourned.